Well, thank you so much, Sam. It's really terrific to be here. And I just wanted to start actually by dedicating dedicating my talk to the memory of Shannon Michael Cain, who was really a great member of the artistic community here in New York and worked on queer zines, art books, and the library here I think he would have just loved. And I think I'm going to try to also sort of add some of the vision and the utopian drive of the library to the beginning of my talk, because what I'm really going to try to address today are what are the promises of technology to make life better, and particularly to make law better. I actually just met with some people that are trying to basically assign legal entity identifiers through machine learning and other big data processes that would make our financial system a lot more transparent, and that's exciting. But I also think we have to watch out for dreams of the future that are kind of scary too. And so I'm going to start with one of those, which is from Max Tegmark. And he has a book called Life 3.0 on being human in the age of artificial intelligence. And his view is that, in the future, the traditional left will die off because companies will provide everything. Then you ask, well, how will the companies provide everything? And the idea is, well, they're going to use artificial intelligence, machine learning to not only figure out how to provide everything as cheaply as possible. So think of Amazon plus universal basic income, I guess. Fully automated luxury Amazon communism, I guess. But also he says, we're going to get rid of all those divisions between people by automating political consent. And there's a vision of this in the Chinese social credit scoring system, right? And I've written about that, and that's pretty scary. But his vision is that the AI would eventually come to own all of these different political parties and media organizations. And people would think that it was all owned by different entities, but actually it was all owned by the same entity, and they were all sort of pushing people towards the consensus views of politics that he articulates. But when you look at the foundation of that vision, what would drive it? It's machine learning, and it's trying to figure out how do you appeal to people, okay? And how you appeal to people is something very binary and basic. Okay? And part of that binary and basic ideal is that you use the same machine learning technology that can separate eventually puppies from bagels. With a big enough training set, they can learn how to do this. And you'd apply that type of technology to what news do people get, right? And so some people are going to get certain forms of news, some people are going to get other forms of news. And you'd eventually, automate consent, or at least the ways that people get information, which is, he intended it as this very utopian vision toward global consensus and global governance, but what we're seeing is it actually is best used in a quite nightmarish way. And I think I just want us to interrogate, how are some of these machine learning methods used? We have the beginning of machine learning, or at least the beginning in many of its most commercial applications, was efforts by banks to figure out how they could decipher the written numbers on checks, right? And so you can decompose these things into different little blocks and then use those to sort of have the classifiers, et cetera. That sort of gets extended to facial mapping, right? Where you have facial mapping where it's not really about the computer seeing something the way that we would see it. It's really about the computer just sort of measuring, how wide are the eyes, how broad are the eyes, how broad are the lips, et cetera. And that, on one level, is a way in which, it has some promise in law in sort of identifying, say, individuals, identifying other cases, but it also has some sort of nightmarish applications, including one that, got a lot of news recently: automated inference of criminality using face images. This is a study by Wu and Zhang. And the people on the top row on the left are, I think, the subtypes of criminal faces. The people on the bottom row are the subtypes of non-criminal faces. And the study is bad on so many levels. It's, it doesn't take into account that maybe prison changes people's faces. Doesn't take into account all the stuff in algorithmic accountability and the stuff that Mimi Onuaha was talking about earlier today about the lack of representation or overrepresentation in certain databases. Doesn't take into account any of that, but strangely, the people behind it actually view themselves as debiasing criminal justice, because they say that automated inference is better than, say, a police officer because the computer isn't racist. But ironically, all the data, or a lot of the data, was based on what police officers of the past had done. So it's kind of depressing, to sort of think about that. But this type of facial recognition technology is going in more and more contexts. It's now being used for something called selfiequote.com. So you can send in your selfie, and they will use that on the basis of looking at your face, sort of extrapolate what your physical condition is and how likely you are to live or not live over a certain period of time. And it's really amazing to sort of see this technology just not really get regulated and not really be thought about on a very high level in Washington. I testified before the Senate Banking Committee in September, and everybody had heard of Black Mirror, but nobody wanted to really apply the lessons of the series to the current situation. And I sometimes talk to US policymakers, but they sort of joke about it, they're scared about it, but it's really within their grasp to, like, for example, make this illegal, right? But they're not doing it. And it's strange, these methods of parsing things, they go all over the place. So even there's a study recently that was done on tone of voice in the Supreme Court. And it turns out you can use how emotionally agitated the justices are to predict how they'll vote, okay? And this sort of thought, this is being used in all sorts of areas. And I just want to apply it and sort of compare it to one particular study, which was really recently released, which was prediction based on a bag of words approach, based on how, and they would look at certain filings of the European Court of Human Rights and predict on the basis of the filing whether the judge would say that there had been a rights violation or not, okay? And the way they did this, it wasn't by exactly like trying to figure out the meaning, like what Alison Parrish was talking about this afternoon, sort of an extraction of meaning via natural language understanding of natural language processing. It was more about, they would just take the words here and they would sort of take all the words on the page and then fill them into a natural language processing approach called bag of words, which I'll get to in a little bit. And let's just compare how that works versus classical, how a judge or lawyer would think. Under classical legal analysis, you'd think about the factual situation of the case and you think about how similar is it to other cases that have been decided in one way or the other, right? You'd apply the relevant constitutional provisions, or here the European Convention on Human Rights, the convention provisions, et cetera. When you look at this study, the machine learning classification, what it did was it assembled a database of text from past cases, it determined correlations between those texts and the outcomes, and it determined whether the texts associated with this case more closely matched those of past texts predicting violations, sort of like saying there would be a violation or not, okay? And these were the factual patterns that were written by past courts in those cases, but they could be like the briefs or other things. Eventually that'll be done, I'm sure. But this is sort of a bag of words approach, and just to give a visual sense of that, here's the sentence. Albert Einstein reflected this when he famously said, blah, 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 et cetera. If you look at like n bigrams, you divide it into all the different pairs of words that are there. Unigrams, it's just the same thing, it's the words in it. Bag of words is how often do certain words come up or not come up, right? And so that's what they were doing with all these past judgments, and eventually they want to be doing with past briefs or description of facts and cases. You just pour in the words, and then you see, does it map to cases where there was a violation of rights or not? And then decide, was there a violation of rights or not? Now they, admittedly, to their credit, they don't want to do it that way with respect to getting rid of a judge and just having a machine learning program taking on these cases, right? But they have talked about using them to triage cases, which I think is still troubling. They get too many cases, they need to triage them. And one version of this is, they talked about the predictive topics for Article 6 violation decisions. Okay, and some of them make sense, appeal, enforcement, court, et cetera. These were terms that were correlated with a violation of that right. But some of them, like copy or individual, it's like, why? Why does it, and they can't really explain it. And this is where I want to propose a somewhat radical analysis of what's going on here, which was inspired by the blog Spurious Correlations. So there's a correlation, for example, that the divorce rate in Maine per 1,000 people is directly correlated to the per capita consumption of margarine, right? So if you're part of the Family Research Council, I guess you should be trying to get much less margarine produced and give people butter. I don't know. But this is sort of one form of spurious correlation. And when I think about spurious correlations and the types of bag of words approaches that could say, well, this word means a lot and this word means a little, et cetera, and predicting how the court will decide, I think that to the extent these other features are explicable in legal terms, they're redundant. Okay, we could do this as a traditional lawyer, or the way that people would sort of look at these texts. You could just sort of analyze them. But to the extent that they're not explicable in legal terms, they're illegitimate because they reflect spurious correlations. For example, the fact that someone put individual in their case as opposed to person, right? Or that it happened that there were a lot of Russians that year had violated rights, but then that might weight future determinations. If you have Russian, and you're more likely to have a rights violation found. And this is part of a step back. I want to take a step back here in terms of expert systems versus machine learning, which is to say that, back in the 80s and 90s, the big hope for people in artificial intelligence was something called an expert system. It was that you'd reduce a domain to a set of rules, apply the rules to new cases, and then add nuance as you capture the edge cases. That had become passé because it's infinite. There's sort of an infinite complexity of fact patterns. And there's a great article called The Law as a Fractal that gets into that. If you think about fractals, sort of this infinite self-similarity complexity as you keep sort of looking at trying to drill down on what's the fractal pattern, it's similar with cases in law. But then what started happening over the past 10 years or so is this idea that under machine learning, there's no need to articulate the rules, right? That with machine learning, you just have enough data and you follow the data, and it's not like you need to understand what happened, you just sort of do what the past patterns of data lead you to do. And that's the question that I have here. I have a certain problem with that because I think that there's a real core to law that depends on meaning as opposed to just matching, right? It's not just about matching like the fast words used, it's about the meaning of the cases and what went on there. And I'm inspired in this a bit by Trevor Paglen's work. So Trevor Paglen in the New Inquiry last year observed that there are like trillions of images out there that Facebook and Google's AI systems are ingesting. And he has this sort of artistic view of, what is enough of a match to be deemed something, right? So I think this one is called, let me just look at my notes, sorry. Oh, goldfish. Okay, so the one on the left is goldfish. So that's like just enough to be a goldfish, I guess, for these sort of machine learning systems. And I think a lot of us would, before I said we learned it was goldfish, we might be skeptical about that as a depiction of a goldfish, right? And I think what I'm trying to do with with both faces and cases classification, is I'm trying to get the legal profession to be a bit more skeptical about the application of some of these methods. Because unfortunately, like in my field, I think a lot of people go into law and they feel kind of guilty about not having done computer science or math, and they're sort of like, oh, well, whatever that process is must be better than what we're doing, right? And I think that trying to question that is helpful. The other thing that I think is key is that, meaning is really at the core of legal practice. And that, statistical analysis can tell us about disparate impact of present practices. So I certainly want statisticians looking at how cases are being decided. As Mimi described earlier today, there's enormous bias in a largely human-driven legal system. We have to address that in many, many ways. But neither faces or cases, I think, should be parsed for criminality or violation or these other terms based on an inarticulable data practice. So part of a lot of what I do is think about what is it to articulate? What is intelligibility? What would an intelligible society look like? And the irony, by the way, is if you push for an intelligible society, you're automatically pushing against the Hayekians, the Friedrich Hayek crowd that says, oh, it's all infinitely complex and we can't understand it, and no planner can understand it. So there's a politics here as well. There's not just sort of an ontology, but there's really a politics here. And I think the alternative is something kind of scary. It's a sense of an adversarial legal system, which is adversarial neural networks battling for the best manipulation of the triage system, of the language, et cetera. This already exists in a company called Lex Machina. This company, admittedly, it mainly looks at the past records of judges in patent cases, but it's clear that all of this sort of technology could be used to say, here's the language that would manipulate that judge just right, but without having a sense of what it is in the meaning that led to the outcome. And again, another artistic comparison is, this is another piece by Paglen called False Teeth, Corpus Interpretations of Dreams. And what he did for this piece is he actually set two neural networks against each other. And what one was assigned to do was to create images that would be just enough to look like a set of false teeth to fool the other neural network into thinking it's false teeth, right? And I think that sort of what's going on in some of these legal systems, and perhaps even in high-frequency trading systems, although I haven't really thought it through, is that if you really take the machine learning natural language processing approach too seriously, you end up making these systems kind of like these adversarial neural networks. I also think that's true with plagiarism detection software. So, if you have, there was recently announced a patent by Blackboard to develop an algorithm to assess the level of critical thinking by students. And I think that what Lucas and Trona has argued is that a lot of times what this sort of algorithmic parsing or efforts at understanding, ranking, and rating individuals does is it sets up the learning environment and it sort of corrupts it from being ideally, and I know this is not always meant, but ideally meant to be a place of communicative action, of understanding, of collaboration, into one where there's somebody that is a gatekeeper and you're like the adversarial neural network and you're just trying to slip through a paper that's like just good enough. And there's wonderful studies of people that are develop nonsense papers that nevertheless score really highly on these systems, right? And so that I think is really important to learn from those things. I would in my concluding sort of thoughts about this, I just want to leave you with a quote from a roboticist. And there's a Nature article called "Can We Open the Black Box of AI?" And a guy named Hod Lipson said, I think we're losing ground to these algorithms. It's hard to explain it. They're so much better than we are. At some point, it's like explaining Shakespeare to a dog, And what I've tried to do in this talk is to kind of reverse that, is to say that in a way, at least some extant efforts to parse legal texts to determine outcomes, it's really that's like trying to explain meaning in law and its role in law is like trying to explain the Shakespeare to a dog. So I don't know, but I would just say that it's before we glom onto these ideas of artificial intelligence leading to a much higher level of intelligence of what we have. Intelligence that Nick Bostrom talks about. Instead, what we see are sort of collaboration among different jurisdictions. And that might seem utopian, but on the other hand, we already have it, all right? And we already have it with the idea, I think, of professions. We have distinct professions. We have separate people who are trained to be lawyers, trained to be artists, trained to be computer scientists, et cetera. And I highly value the work to bridge those fields, but I hope that our endpoint is never to merge the fields. Because, as the sociologist Will Davies has said, any way of thinking that set itself up as being the master profession, the profession to understand all other professions, would be an epistemological tyranny. And I think that when I read in Pedro Domingos' book, The Master Algorithm, that he believes that we could have an algorithm that could just sort of do everything eventually, or any of the speculation on algorithms doing everything essentially, or displacing us entirely. I think it's part of that epistemological tyranny. So, with that, thank you.
Thank you so much, Frank. We can take a couple questions from the audience, if anyone has any.
Hi, thank you. Machine learning seems to advance in a field when a public data set becomes very much available. So for example, the Netflix prize came out and then recommendation systems became a really big topic. ImageNet came out and then computer vision became much more possible. Can you work it from the other direction? Like what data set would you want to make publicly available to push the field in the area where you think it should go?
I love that question. So it was funny because I actually had to slip away because I was talking to these people that were developing a system for legal entity identifiers on corporate entities. And part of my book, Chapter 4 of the Black Box Society, I talk about why the financial crisis was so severe. And a large part of its severity was due to the opacity of the financial relationships between a lot of these really big banks and other firms. And that's an area where, the analogy they drew was these were people coming out of the oil industry. And they said that whenever you have like oil machinery, that if you have it in Scotland or in Singapore or Indonesia, they will know and they'll be able to understand how the flow of oil works. And their dream is that eventually, using the methodology that they're developing, others are developing, that data would be able to flow with a similar level of granularity of insight and standardization. Now, of course, though, I have to step back a bit by saying that I don't totally buy into the project of like trying to get algorithmic description of all financial relationships, because first, it's like a privacy nightmare, and secondly, that it may oust certain forms of legal work that I think are really ideally legal work rather than computer work. But on the other hand, to be able to really keep track of who owes and owns and the flows of funds, could help us stop things like the Panama Papers, Paradise Papers, and stuff like that. So yeah, I mean, that's an area where I really hope we get a lot more transparency and a lot more data. And it reminds me of Mike Consol's review of Piketty. This guy, Mike Consol does some great work at the Roosevelt Institute, and he said, the reason why Thomas Piketty's Capital in the 21st Century was so controversial was because a lot of foundations love to give people money to study the poor, but then all of a sudden when you study the rich, it's like, and that's like Rachel Sherman's new book too, right? I mean, she's looking at a lot of the lives of the wealthy, but from a more qualitative angle. So yeah, I think that type of parsing of power relationships and money relationships, that to me is highest on my list. Yeah, thanks.
Hi. What do you think the role of like databases like LexisNexis or like Westlaw, and how those case law databases and the suggestions and like the search indexing that occurs on those plays kind of into this idea of like biasing law and like legal precedent from like directly to the judges or even amongst lawyers themselves?
Oh, I love that question. Recently, there was a guy named Robert Epstein who has studied what he calls the search engine manipulation effect on voting. And he has done empirical research showing that the way in which, say, the top search results for different candidates' names or other things, that can really bias people's conception of the voting, of who they should vote for. And he wanted to do with me an experiment on lawyers where we would have one set of results go to a certain group of lawyers that would have a certain set of cases that were pro-plaintiff at the top, and another set be that were pro-defendant. And that we would do empirical research to try to demonstrate a search engine manipulation effect on attorneys. Ultimately, though, I resisted that way of framing the experiment because my sense is that you have, as an attorney, a professional obligation to do due diligence in all the cases. And so I think, it made me think about, but there is a growing, well, I should say it's an emerging literature that this bias effect is real, and we need to look into it a lot more. But I think about it less as a lawyer and more as an academic and who people cite. Because I think the citations, that really worries me that like the Matthew effect is just going to get worse and worse and worse to the extent the search engine algorithm is weighted by what's already been cited, what's already connected to. Yeah. Thanks. All right. Thank you.